At the outset, I'd like to thank Deputy Mayor Saskia Brownis from the Municipality of The Hague and the Embassy of the Netherlands for their support and sponsorship of this session. This is the 6th year that the Society, the City of Den Haag, and the Embassy of the Netherlands have worked together to bring key international figures from The Hague and from around the world to the ASIL annual meeting. At this point, I'm going to introduce the moderator for this panel, Dr. Ernst Hirsch-Ballen, and turn the proceedings after I've introduced him over to him. Dr. Ballen was the Minister of Justice for the Kingdom of the Netherlands from 2006 to 2010, and earlier from 1989 to 1940. In that earlier period, 1989 to 1994. Going backwards, that's what happens at the end of an annual meeting. In that earlier period, from 1989 to 1994, he was also Minister for Netherlands, Antilles, and Aruban Affairs, and from February to October 2010, Minister for the Interior. From 1999 to 2000, he was a member of the convention charged with drawing up the EU Charter of Fundamental Rights. He was subsequently appointed to the Dutch Council of State from 2000 to 2006, becoming chairman of the Administrative Jurisdiction Division in 2003. More recently, he's been a professor at the University of Amsterdam and Tilburg University, and is currently the president of the Asser Institute for International and European Law at The Hague. So it's my great pleasure to turn over the proceedings to Dr. Ballen. Thank you.
Thank you, Madam President, for this kind introduction. We are here with a delegation from The Hague, and one of the parts of the Hague delegation is that from the Asser Institute, and it was a pleasure for us to organize this panel in cooperation with the municipality and the Royal Dutch Netherlands Embassy. Thank you all for joining us at this closing plenary on building trust in international law and institutions. The developments of the international legal system was one of the great achievements of the 20th and early 21st centuries, based on the principles of multilateralism endorsed at the Hague Peace Conferences, which were the work of Tobias Asser, after whom our institute is named, and his counterparts from Russia, the United States, other European countries, and also, for instance, Uruguay. The landscape of international cooperation has changed dramatically over the past year, and several panels and sessions at this annual meeting were devoted to these changes. That was, if I may say so, as a member of the Society, an excellent choice in your program to do so, and to adjust the program also with some new components dealing with recent developments. Changed dramatically, as I said, with such developments as Brexit, the announced withdrawal of states from the International Criminal Court, and the ongoing political developments in the United States and in Europe that further erode trust, our subject in international law and multilateral institutions. What international law values? That was the theme, is the theme of our annual meeting. And that was and is the theme of this panel as well. Trust, of course, most of all values in international law. Trust is the core value and defining purpose of the law altogether, isn't it? Since in any developed society, neither familiarity with others can guide our behavior, nor subjugation to a supposedly superhuman ruler. Mankind needs laws and law enforcement. That allows us to coordinate our expectations, establish reciprocity of these expectations, and discourage deviant behavior. The purpose of international law in the relations between states, including their citizens, is not different. However, the systems through which trust is reinforced and maintained are much more disaggregated and permanently challenged by international power play and unruly actors. Building and maintaining trust through international law is a complex affair. The research program of our institute is devoted to the legal processes and institutions which create and support trust in international relations, which requires, of course, to uncover also the mechanisms which diminish trust. We are really grateful that we have an excellent panel for an investigative discussion of this subject, trust in international law and institutions. Philip Alston from the Newark University School of Law. Maurice Camteau from the Hague Academy for International Law. And I thank the Academy also for the cooperation in the preparation of this panel. Judge Bruno Sima from the University of Michigan School of Law. And Judge Christine van den Wijngaard from the International Criminal Court, who will be the first speaker of this panel. Trust in international law and international relations depends on several requirements, and I hope the panel will be able to deal with these requirements. Procedural and substantive requirements, following the rules of investigation and independence with respect to partial interests. Trust also depends on the trustworthiness of persons in whom we vest trust, their professionalism and expertise, and the righteousness of their mindset. Trust in international law and international relations also depends on the ability to communicate with different groups, peoples, and nations, something that is certainly much more difficult the more diverse the situations are with which the institutions have to deal. And here I refer once more to the various sessions of this annual meeting in which the interest not only of states and institutions, but also those of the victims of crimes against humanity, of infringements on the protection that we pretend to offer on human rights were discussed. And that is one of the remarkable changes, I think, in the program of these of this panel, of this annual meetings over the years, that the interest has shifted gradually from institutions and states to including also persons, victims, persons who deserve the protection also of international law. And I was really, as a member again of this society, happy and touched by the way in which various panels dealt with these interests of people who are in danger, victims, downtrodden people. We will start this session with Baroness Christine van den Wijngaard, a former professor of criminal law at the University of Antwerp, who has served and will continue to serve as a judge in the widest possible variety of courts and tribunals based in The Hague. So she is, although Belgian, certainly a representative of The Hague as the city of peace and justice. She was an ad hoc judge in the at the International Court of Justice in the Yerodia case, a judge at the International Criminal Tribunal for the former Yugoslavia, and since 2009, judge of the International Criminal Court. And her most recent appointment was that to the special chambers of the Kosovo Criminal Court, also based in The Hague. She will open the session with her observations on the role of international criminal law in building and maintaining trust in international relations. Chris, the floor is yours.
Thank you, Professor Ballin. As you can see, I'm a veteran in the field of international criminal justice, having served on all these courts. I came to The Hague in the year 2000 for the arrest warrant case at the ICJ. And looking back at that period, it feels like these were the halcyon years of international criminal justice. The ICTY was up to speed, the ICTR, the ICC had been created, the Rome Statute was brand new, states were exercising universal jurisdiction. In the UK, we had the Pinochet case, so everything seemed to go in a very much forward, positive direction. Today, things are different. The pendulum is swinging back, not only for international criminal courts and for other adjudicatory bodies, but for states in general. We have the general trust crisis, the trust implosion that we can see from various statistics, like, for example, the Edelman Trust Barometer has measured that in the year 2017, there's an enormous implosion of trust, explosion of distrust in all over the world, and of course, mainly felt in democratic states. The Brexit, the last elections, and not to forget the upcoming elections in France, which will be looked at with much anxiety. So the question is whether this trust, which is mainly the trust crisis, mainly in relation to governments, to the economic community, think of the 2008 banking crisis, the Panama Papers. There's also a distrust in the press, which means that the press can no longer exercise its function as watchdog so much as it could do before. So there's perhaps more than ever a need for trust in courts. So what I'm going to look at in this, these moments that I have for me is to look at the International Criminal Court and to see to what extent the International Court is also the subject of a trust crisis. When talking about the International Criminal Court, the first question we have to address is, when we deal with trust, whose trust are we talking about? Because as we all know, the International Criminal Court is many courts in one. It's obviously a criminal court, judges deciding about guilt or innocence of suspected persons. It's also a victims court, victims-oriented court, victims' participation, victims' reparations, which makes the court also a civil court in part, because we have to deal with questions that have never been dealt with in international criminal courts. We are also a court dealing with the responsibility of states in a way that the ICJ is doing its work. So, for example, as you may know, last week we had a very important hearing about South Africa, with South Africa present in the court, making submissions on the question as to whether the refusal to arrest al-Bashir was or was not in an infringement of the Rome Statute. So all these different tasks that we have is what Yuval Shani has called goal ambiguity. There's many different tasks which sometimes are competing with one another. So it may often be the case that judges fill in their mandates in a very different way. You have the more black letter oriented judges and the more human rights oriented judges who would possibly go for a different, more teleologically oriented interpretation of the law. So let us now look at what distrust exists in the ICC and what the problems of today are. Let me start by saying what I think is not a problem with the ICC, not a cause of distrust. The ICC has been accused of many things. There's many problems, but the ICC has never been said to be a runaway court. Like we have the criticism of the European Court of Human Rights, for example, where in some circles the court is blamed for having turned the civil and political rights protection into an economic and cultural right protection. And as you know, even before Brexit, Theresa May was seriously considering a withdrawal from the European Convention on Human Rights, which I think would have been dramatic, possibly even more dramatic than Brexit. So that's something that at least the ICC is not accused of, because we are much more legalistic, even much more legalistic than the ICTY, which in the Tadic years could be very broad in interpreting customary international law. That's not something that arises at the ICC, because we are much more treaty bound. And of course, there are criticisms, disappointments in the ICC, the slowness of the proceedings, the high cost. I was thinking in the past few days what the costs were of the Tomahawks and the big bomb that was dropped 2 days ago. But it's true, international criminal justice comes at a price. There's the disappointment with the victims' participation system. It has been discussed yesterday. Susan Sakuto has been very critical about it. All these things are happening. These are problems that the court is facing and trying to resolve through its jurisprudence, through its best practices, etc. But I don't consider those points to be signals of distrust. For me, distrust of a court is when the parties, the participants, are considering the court to be, are blaming the court for being partial, for a lack of impartiality. That's where I think the main focus lies when we are discussing trust in international courts and tribunals. And so on this point, I want to look at two different problems that we have in the court. The first one being the selection of situations, a very well-known problem. The second one being the acceptance of the court's jurisprudence in situation states. Let me come to the first point. It is well known that there is a huge criticism on the court for being Africa-oriented. It is true that all the cases that are pending now before the court are African cases. And as you know, there have been threats in the African Union for a mass exodus. It's true, as I was saying, the cases that we are having now are African cases. But if you look at international criminal justice in a more holistic perspective, and look at the last 20, 30 years, and take into account the jurisprudence of the ad hocs, then we see that many more indictments have been served in a European situation than in African situations. So looking from that perspective, the picture may be somewhat different. But it is true the ICC has a global, potentially global jurisdiction, whereas the ad hocs didn't have that problem. The ad hocs had prosecutors who had to focus on a particular situation. There was no choice of situation. And this is a great responsibility on the ICC prosecutor, that she has the power under the statute to even proprio moto start investigations. And of course, there is an explanation for the reason why we have these African cases, because, as you know, most of the situations were referred to the court by the states themselves, the self-referrals. And the two Security Council referrals were also about African states. This being said, there may be a problem of overemphasis on Africa. But if you look at the criticism that has been voiced, it mainly came at the time the ICC was applying Article 27, the non-immunity clause. Before that, when we had the Katanga case, the Lubanga case, the Ngodo Ojolo case, these criticisms were not really formulated. So there seems to be some irritation over the court exercising its duties, its power, to go after the highest responsible. This is the logic of an ICC. That's why we have this non-immunity clause in the statute, because the idea is that the highest responsible political and military architects of atrocities would be standing trial in The Hague. And here there has been this reluctance of mainly African states to accept it, which is reflected in the Malabo Protocol. The Malabo Protocol in Article 46b grants immunity to African heads of states and African high officials. So this is something that will probably need to be sorted out in practice. I'm not going to deal with this much in detail because it's something that has been discussed in other panels as well. So far, things are not so dramatic because, as you know, South Africa and Gambia, who initially had decided to pull out, have decided to stay in the court. It's only Burundi that is now trying to leave the court, and we will see whether that will eventually happen. What can be said is that the court is trying to draw lessons from this. And if you look not at the pending cases, but at the preliminary investigations that the court is doing, then you will see that out of the 10 situations under investigation, there are 6 situations that are out of Africa. So that, I think, is really an improvement as compared to what we had in the past. Let me now turn to my second point. the acceptance of jurisprudence of international courts in situation states. There's not so much that can be said yet about the ICC, because the ICC is a young court. We only had our first cases, and so there's no real research on this. There is research on acceptance in the ICTY, in the Yugoslavia Tribunal. And there, I must say, for me, personally, this is my biggest disappointment in the work that I've been doing over the years. At the ICTY, I had the feeling that with my fellow judges, we were drawing the record of the atrocities committed during the Balkan Wars, that we were doing something like the Truth and Reconciliation Commission in South Africa had done, drawing the record, a record that then would be the official narrative, the narrative that would be followed in these situation states. Unfortunately, that didn't happen. And the narratives that existed before the ICTY are still there. The ICTY has not been able to change the narrative. Marko Milanovic, as some of you will know, has done extensive research on this, and it's very disappointing to see that it's not happening. And the reason why, he says, is that it's the elites. If the incumbent elites are threatened by the jurisprudence or are not accepting the jurisprudence, then there is little an international court can do, even if it produces the best jurisprudence of all worlds. And that's the problem with the ICTY. If you compare to Nuremberg, Germany, there the acceptance was difficult, but eventually it occurred. In part also, according to Milan Milanovic, because of the press, because the Allied controlled the press. If you compare to Japan, for example, there the situation seems to be different, and there is, as you may have noticed, a rise of denialism that has started in the 90s, and that is unfortunately progressing. So what to conclude from all this? Is the ICTY really in a downward spiral? Is international criminal justice in a downward spiral? I don't think so. And I'm looking at this with the eyes of a veteran. I'm not such a veteran like Ben Ferencz here present, but I'm also looking at it from a perspective of 20 years. Indeed, if you compare the court with 20 years ago, as I was saying in the beginning, the halcyon years, then you would see a serious regression. But if you look at it from a broader perspective, which I have been doing as a Belgian, I have been giving speeches, 11 November speeches, remembrance of Armistice Day, First World War. If you go back to that period, if you go back to Versailles, to the Treaty of Sèvres, where there was an initiative to put the Ottomans and the German Kaiser to trial, it didn't happen. There was no political willingness of states to do it. It was in the treaty, but the treaty was not applied. If you go to 1945, the year when Ben was doing his work, they had to start from scratch. There was nothing. When they drafted the London Statute, the Nuremberg Charter, this architecture of war crimes, crimes against humanity, crimes against peace, was totally new. And the court and the prosecutors and everybody working had to put it together and develop it. If you then go to the 70s, and I'm using that because that's the time when I had the age of those youngsters who have been doing the Jessup competition here. When I was looking at this, I had no perspective of ever seeing an international criminal court in my lifetime. The Cold War was on. Even in Europe, we had fascist regimes. Spain, Portugal, the whole of Latin America was a disaster. The Vietnam War. There was no perspective, anything else but the Russell Tribunal. But apart from that, nothing was happening. So looking at the ICC and the status of international criminal justice at this point in time, I don't think we must be too disappointed. This historical perspective can give us the courage to do what we must do, and that is, and I refer to what Ben Ferencz said yesterday, don't give up, don't give up, don't give up. Thank you for your attention.
Thank you very much. Thank you very much, Christine, for this realistic and nevertheless hopeful perspective on your work and that of others in international criminal law. I now turn to Bruno Simma. First, Bruno Simma. Bruno Simma, whose scholarly work is inter alia devoted to the United Nations organization, served as a judge in the International Court of Justice. He's a former dean of the University of Munich Faculty of Law, a former judge at the International Court of Justice, as I said, a member of the Iran-United States Claims Tribunal, and teaches at the University of Michigan Law School. He will discuss the significance of multilateralism as a key to trust in international law and institutions. The floor is yours, Judge Simma.
Thank you, Mr. Hirsch-Ballin. I'll follow your instructions, although with a light bend, but into a neighborhood that you'll probably agree with. But I think we all agree that multilateralism is the arena for the march from bilateralism to community interest, among other fields, also with regard to the settlement of disputes and the maintenance of peace. And I consider it one of the great endeavors and partly achievements of civilization. Now, if you have between 5 and 10 minutes to discuss one of the great endeavors or achievements of civilization, you better be selective. That makes me, let's say, turn in a certain direction. And I'll focus on particular aspects and appearances of multilateralism, namely what I would call, just for the sake of brevity, judicial multilateralism, in the sense that I'm going to say a few words about multilateral activities and institutions designed to foster the rule of law in international relations and settle international disputes peacefully. And with that, I have arrived in The Hague, a place that Jan Paulson, in a recent publication called The Hague, the Peace Palace, the coal face of international dispute settlement of international law. And I think it's worth reminding you that in already more than 100 years ago, The Hague was the place in which the first multilateral conferences, among other things, dealing with the peaceful settlement of disputes, took place, 1899, 1907. Well, soon thereafter, of course, you had World War I, and the institution designed and put on place already in 1907, the Permanent Court of Arbitration, fell into, let's say, hibernation. Well, winters in The Hague are not that terribly long, but I think it was a wallflower for many decades. But in the last 15 to 20 years, I think it has actually been almost reborn. I think it must by now approach, have close to 100 cases, maybe this is already obsolete, close to 100 cases on its docket. And among these cases, a number of arbitrations. Actually, I would say that if states consider or plan to go before an arbitral tribunal, I'm talking about interstate cases, I think they will now almost inevitably end up in The Hague before the Permanent Court of Arbitration. And of course, on the other half of the Peace Palace, you have the International Court of Justice, and under the heading of multilateralism, of course, this is really the principal judicial organ of the world, of the United Nations being more or less universal. The ICJ is a real world court. It has universal membership in the sense that if you are a member of the UN, you are automatically also a state party to the statute. And the state party to the statute obligates you to a number of things, among other things, to contribute to the expenses of the institution, which is not the least of the, let's say, aspects to take into consideration. Within that multilateral system of the World Court, the ICJ, you have what you could call a plurilateral subsystem, which is that of the optional clause. I had the pleasure of chairing a a meeting on new voices just before this event, and one of the speakers there thought that the system of the optional clause was healthier than it was before, and that reminded me that if you are as old as the optional clause system, you're probably happy with your health remaining as it was, and that is how I would regard let's say the state of the optional clause system. It's in relatively good shape. We have had a number of, let's say, among major states joining the system, and this is the only instance in which I'm going to quote myself. As I wrote a few years ago, when you join the optional system, the clause system, you make an important declaration of trust in international law. It is a principled commitment to peacefully settle disputes, and the participating states are willing to put their money where their words are. That much, Sima. Just a little side glance. I had the opportunity to speak with one of the editors of the American Journal last night, and he told me that the largest part, the greatest percentage of manuscripts they get for the journal is on international courts and tribunals. My guess is that probably out of these, let's say 100% of these manuscripts, 55 will be on investment tribunals, 35 will be on international criminal courts and tribunals, and the rest will be on the traditional stuff I'm talking about. But of course, all these tribunals together form part of what we are looking at the moment. Some of you might have had the great opportunity to listening to Professor Abisab in his Manlio Hudson interview with Philip Alston. And he is such a master of crafting these images of things of international law. Philip, how did you call it? The word? Wordsmith. A wordsmith. Yeah. And one of the smith of an image was this image of international law being a creature or a body without the skin. I hope I got you right, George. Without the skin, meaning that international law simply does not have that skin that you can see around countries, the sovereignty, a wall here and there, maybe immigration offices. So it is much more vulnerable to international reality, to attacks. It is exposed to international reality to a much larger extent than domestic law. And I think this special vulnerability and exposure is also true with regard to international courts and tribunals. And there is no ground for complacency with the state of affairs as we have it. I think it is so easy to destroy within minutes, maybe by Twitter, what people have taken decades to build up. And that gets me to my more or less third and last remark, which goes as follows. I think we all agree that walls are only very exceptionally a good thing. When I wrote up my notes here, I was reminded of what happened 15 years ago around The Hague, or at least on the beach of Scheveningen. In 2002, this country enacted the American Servicemen Protection Act, which provided, and I think you could say which still provides, I think the law is still in force, that if American servicemen happen to end up within the, let's say, scope, whatever, of international criminal law as embodied in The Hague, the United States would, I quote, employ all means necessary and appropriate to kind of free them from the grip of international criminal law. I remember in 2003, we had the usual cocktail party in the ICJ following the hearing in the case of oil platforms. And I had a chat with the then legal advisor, Mr. Taft, Roman 2 or 3. And I said, this is probably, are we going to do we really need to take that seriously? Because the act had already gotten that name, the Hague Invasion Act, and he said that's not meant to be serious. And he said, no, don't count on that. Don't count on that. That it might be serious. Okay, so much the then legal advisor of the United States, and what happened as a defense. A typical Dutch defense was that on the beach of Scheveningen, some NGOs put up a wall of sand, which was the symbol for what Europe can do against an attack from overseas. Now, when I googled the net just to see what the designation for that law was, I came across entries which said this Hague Invasion Act and the defense might have a new reality, a new topicality, with the ICC now looking into alleged or potential.
Afghanistan. Afghanistan.
Yeah, it has.
Well, it's one of the preliminary examinations that have been opened.
It has begun to examine alleged war crimes by US soldiers in Afghanistan. All right, so that I leave that. Trust, danger. But if we are going to face an erosion of trust in international law and international institutions, the time will have come to build a political wall, a new wall in The Hague, in order to preserve faith in the Hague judicial institutions and to defend what we have against attacks from the outside. But unfortunately, this is my last point. There might be the necessity of defend the acquis, the great acquis we have in and around the Peace Palace, also at the inside. And with that, I refer to something which has really kind of which concerned me a lot. Apparently, there is a possibility or a danger that the library of the Peace Palace library will be closed down due to financial considerations and kind of problems between various ministries in the Netherlands. I'm a bit blunt, Mr. Hirschbaum, but I think this is really of great concern to me, because I think the Peace Palace library, which is probably the greatest library, at least on the continent, better than Max Planck, even in Heidelberg, on international law. I think it's an integral part of the system that we find in the Peace Palace. If that library went just out, not only the students would be, let's say, affected, it would also affect the work of the PCA, to a great degree also the work of the ICJ. I would be ready personally to do what I saw other people doing in front of the ICJ. I would go on strike there for the maintenance of the peace library. I think it would be such a great loss. And I plead, this is the city of The Hague in the first instance, the organizer, for the city to do what it can, but also for the government of the Netherlands to really consider what they are doing to the system in a particularly, let's say, vulnerable period of time. Thank you very much.
Thank you very much, Judge Sima, for these important observations. As far as the library of the Peace Palace is concerned, the Asser Institute, and especially my colleague Janne Nijman, who is our academic director, is part of efforts together with other institutions, like also the Hague Academy, to keep the library, the tremendously important library, alive. And I trust that your words will be heard also in The Hague. Your observation concerning walls will remind us, I think, throughout this debate and afterwards, that walls are a symbol of distrust. Thank you for that. Maurice Kamto, Professor Maurice Kamto, is a member of the Curatorium of the Hague Academy of International Law, a member of the Institut de Droit International and professor at the Yaoundé de Université in Cameroon, and the former chairman of the International Law Commission of the United Nations. He will add a perspective of the different regional frameworks of trust-building institutions and arrangements to our subject and speak about the recent disputes in Africa on the impartiality in the enforcement of international criminal law. The floor is yours.
Thank you. I'm sitting here on behalf of the Hague Academy. I'm grateful to the curatorium of the Academy and the City of The Hague and the ESSA Institute for International and European Law for making my presence here possible this morning. The implicit assumption of the theme of this closing roundtable is that there would be an erosion of trust of states in international law and in international institutions, in particular in international courts. But is there really such a phenomenon? Are we in a phase of decline or rise of international law? I personally have some doubts about such idea. Admittedly, there have been cases of violations of certain key provisions of international law in recent years, be it the controversial use of force or changes in territorial status. But whatever one may think of it, there is nothing new. There have also been more recent development, particularly in 2016, in the international policy of some states that have a significant impact on international law in some of its fundamental principles and legal stability in international relations. This is the case with regard to the questioning of treaties, either by pulling out of such treaties or by the requirement of their renegotiations. As such, these phenomena are not really new at all. And moreover, they are situations provided for by international law itself. I'm aware that the impact of Brexit and the new foreign policy of the United States on the development of international law cannot be overlooked in the short term and perhaps in the medium term, if only because the theory underlying these phenomena exalt the return to bilateralism, particularly in the field of international trade and perhaps in other fields of international activity. Indeed, it seems to me that we are witnessing a certain evolution of the classical model of the construction of international law and multilateral institutions. The change is characterized by some nationalism and, above all, the rise of legal regionalisms. As a result, there is an unprecedented development of regional legal instruments, often in areas where there are already universal legal instruments. This tendency towards drop of legal universalism for regionalism or bilateralism reveals, on the one hand, the lack of common values shared in international order or the erosion of values that were believed to have been acquired. On the other hand, the desire to promote normative particularities as a counterweight to a unilateral universalism built on the values of a part of the world which makes little effort to take into account expectations of other regions. It must be realized that market uniformity has not been accompanied by a standardization of the set of values underlying the rules of international law. Then let's therefore ask a few questions. Is preference for regional law and regional justice circumstantial or sustainable? Is legal regionalism merely a geographical dictum on international law, or does it express a more profound phenomenon of mistrust of global rules by the construction of lex specialia? Should this be the case, should we be concerned about, or on the contrary, see new developments in international law that are more in line with the diversity and complexity of the world, beyond the perspective of uniformity proposed by globalization? The rise of jurisdictional regionalism in the face of the classical model marked by centralization and geographical concentration of institutions expresses, without any doubt, a desire for identity or community affirmation, but also a disagreement with a biased jurisdictional universalism. While normative regionalism is based on the diversity of foundations of values that are not integrated or simply harmonized, jurisdictional regionalism in its recent manifestation, especially through the desire of a collective withdrawal of African states from the ICC, is mainly a question of power relation within the international arena and of the perception of international justice. Moreover, jurisdictional regionalism is not expressed in the same way in all spheres of international life. The International Court of Justice is still attractive as the principal organ of the interstate justice, despite the decline in the acceptance of compulsory jurisdiction over the past 2 decades. However, there has been an increase in the number of contentious cases brought before the court during this period, which is considerably higher in comparison with the first 4 decades of the court's existence. The court faces competition, but it is with other universal jurisdictions such as the International Tribunal for the Law of the Sea and interstate arbitration, and not with regional jurisdiction. It is true that the ICJ is not immune from criticism and would benefit from taking into account a series of concerns, which I must say do not, in my opinion, really affect its credibility nor the authority of its decision. The announcement of a possible collective withdrawal of African states from the ICC is both a consequence of a paternalistic view of international relations and revealing factor of the weight of perceptions in international actions. Indeed, after an enthusiastic adherence to the Rome Statutes and the fight against impunity, without distinction due to the origins and status of the person alleged to be guilty, African states quickly became disillusioned with what they considered to be a political instrumentalization of the ICC. Court proceedings against current African states in which the Security Council has ignored the position of African states created a situation of suspicion of most of these states vis-à-vis the court. The primary responsibility for the erosion of trust comes in this case from the court itself, or even from the Security Council. Despite its repeated statements, the court has so far been unable to hear cases involving persons coming from other regions of the world, giving the impression of being only an African court, ratione personae. George has touched upon this point, but If need be, I'll come back on it during the discussion, because I'm not sure that the African states have changed attitude, because the trial now is not against head of state, because after all, the decision for a collective withdrawal has come after the trial of Lubanga and so on and so forth. So it's not because head of state were particularly targeted at that time. Despite, the African state argued that Africa is not the only continent where crimes that can be referred to the court are committed, and that since the ICC has lost its global appeal, it is better for them, for African state, to take over control in this domain. Finally, the absence of a platform of values shared by all members of the international community, legal and jurisdictional regionalism does not in itself appear to me to be a sign of distrust of international law. It is also a way of constructing contemporary international law on the basis of rules adapted to the specific characteristics of states which consider themselves to have a common understanding and destiny, especially in areas where normative universalism proves impossible. But ultimately, it is always a matter of international law, for it's not international law only what is universal. We will see where this trend will lead in decades to come. After all, perhaps this is the future of international law, or at least a necessary step for its construction according to the universalist pattern. I thank you.
Thank you, Professor Kanto, for this perspective on a new balance, if I may say so, between universalism and regionalism as a contribution to trust. I finally turn to Philip Alston, who is the John Norton Pomeroy Professor of Law at New York University School of Law and co-chair of the Law School Center for Human Rights and Global Justice. He has held a range of senior United Nations appointments, including United Nations Special Rapporteur on extrajudicial, summary, or arbitrary executions. And he has written extensively on fact-finding, one of the most important conditions of trust. And I think he will focus on this in his presentation.
Thank you. I will focus on fact-finding since I was asked to do that, but I also want to address some of the broader issues that have been brought up on the panel. I'm not going to look at fact-finding in a narrow way from a human rights perspective, which I've written about, nor in terms of judicial fact-finding, which is obviously of great importance in The Hague. I should hasten to add that I'm the interloper on this panel. I am replacing someone else. I am not associated with any of the judicial institutions in The Hague, and so my perspective may be a little bit different. In terms of fact-finding, I think we need at a certain point to take the very broad picture view of it. We are in an age where we've never had so much access to so many facts. We're also in an age of misinformation or disinformation, whatever the appropriate term is. It's almost sad to look back to the revelations of Edward Snowden about the NSA in this country, the stir that it caused when it was revealed that Dilma Rousseff and Angela Merkel's phones had been tapped. The response to that has been for basically every country to establish not only, or to re-establish and to reaffirm not only its own strong intelligence capacities, but for armies of hackers to be set up in all major countries. This is a major feature of the international legal order, if we can call it that, but of course it presents a fundamental threat. The response to the disinformation then is the campaign about fake news or alternative facts. And of course, while people are disparaged for resorting to such terms, as they often should be, the truth is that it's not easy to find the facts, and it is easy to fabricate facts. We've long been told by the deconstructionists and others that it's all in the eye of the beholder and that no facts are able to be definitively established. But I think we would agree at least that it's the role of international law and international organizations to try to establish processes and institutions and so on, which are able to respond to that critique, which are able to create objective findings which can then guide us. But in a whole range of areas, no matter where we look, my own principal field is human rights, but we think of chemical weapons. Most recently, we think of the downing of airliners, the identification of armed forces in different areas, endless challenges in the field of international humanitarian law, and so on. All of these create or present great challenges in terms of the fact-finding techniques that we are using. In the narrow human rights area, there's been considerable progress. There's a vastly greater reliance on commissions of inquiry. Those commissions have been getting increasingly sophisticated in the way in which they work and the array of findings that they're able to genuinely vindicate. But I think that if we step back and try to look at the overall situation, if we ask how the UN and associated international organizations are doing in relation to fact-finding, it's not a very encouraging picture. I don't think we see much coordination among different organizations. There's still a siloing of what goes on. There's the occasional joint mission with the Organization for the Prevention of Chemical Weapons and so on, for example. But essentially, it's all siloed. We don't have a real effective collaboration. We actually, in the UN context, have very little real sophistication in terms of modern technologies. The UN remains, it's largely driving a Model T Ford in an era when that has long been surpassed. I think that we need the UN to begin to explore the use of new technologies. We see this on an ad hoc basis, so we can talk about the use of crowdsourcing in terms of various crisis mapping enterprises and so on. We talk about the use of satellite imagery in specific contexts. We talk about forensic architecture being useful and so on in reconstructing scenes. But there is no overall focus on the role that the UN might play in response to all of these new information and communication technologies and how its fact-finding across a broad area could really be improved. I think it would be a very good initiative if the new Secretary General were in fact to set up some sort of committee of experts or whatever to actually, committee of very sophisticated experts, those who are well informed about the new technologies and how they might be used to try to get the overview. Finding facts, of course, is only the first step. Once those facts are found, they should be respected. And we do have to acknowledge that there are dramatic double standards in this area. that all of our own countries are able to and regularly do reject facts that have been pretty clearly established internationally, and we need to work on that. I worked last year at great length on the responsibility of the United Nations for bringing cholera to Haiti. The facts, I think, are absolutely incontrovertible, but those facts are not accepted by the UN, despite all of the evidence, not accepted by key states, particularly in the P5, and the facts are completely ignored. There is no acceptance of the clear responsibility of the UN for bringing cholera. So that's a depressing element, I think. Let me turn briefly then to the broader challenges, and here I probably reflect a different perspective from some others. I do think that international law is in a phase of crisis. I do think that there are pretty major long-term threats that are erupting. Certainly from a human rights perspective, we see rapidly growing nationalism and xenophobia, reminiscent of the 1930s, linked to racism and other phenomena. We see the closing of borders and the rejection of the relevant norms relating to migration and asylum and so on. My own country, Australia, has led the way, I'm very proud to say, in utterly dismissing the relevance of international law to its treatment of asylum seekers. We see armed force being not just used, but also threatened on a daily basis. We see the risk of a huge escalation these days of a turn to armed force as the most effective way of resolving disputes. We see in places like the South China Sea the rejection of the law of the sea. We see democracy norms being undermined in ways that we thought had passed. The halcyon days that were referred to also apply in terms of norms of democracy. We're going backwards. We see major threats to the funding of international organizations. The best way to undermine international organizations and their effectiveness is to withdraw their funding. The sort of plans that are afoot there are well known and would be devastating if they come about. I want to end on a slightly contrarian note on this panel and say that I think it's very important for all of us to put the role of courts and judicial institutions into perspective. I teach international criminal law. I believe very strongly in the role of the ICC. I pray for its success. But let me give you a little parable. Imagine that there's a major fire burning outside your home. You see some people going past, and you ask them to help you to put out the fire. They respond, "We're very sorry, but we are plumbers and not firefighters." The relevance of that is that I think that, and Bruno Simmer's comment about the majority of submissions to the American Journal focusing on judicial institutions and so on, I find deeply depressing because the firefighters need to go outside and grapple with the broader range of causes. And while those of us who are involved with judicial institutions do extraordinarily important work, I think the broader community needs to make sure that it is not focusing unduly just on those issues. That's what we're trained to do as lawyers. We're homing pigeons for courts, but we need to see that the broader range of threats, the challenges that international law faces, are not very often going to be resolved, at least primarily, by courts. So I think what that means, and this is a theme that Philippe Sands and others have raised, It means that we all need to work out how we can stand up to defend international law in our own different ways. Most of us are engaged in some ways with governments, our own or others, even with corporations and so on. There are endless opportunities there for standing up for international law, but all too often they are absolutely not being taken. Finally, we need to express a greater solidarity, I think, with those lawyers who are standing up for international standards at the national level and are being subject to terrible persecution. I would just close on the note of mentioning one particular individual, just to let you know what happens and why international solidarity is required. I visited the Philippines back in 2008, 2009. I inquired into the existence of death squads to large numbers of killings. I met with then Mayor Duterte in Davao City for an hour. The person who did the most in response to the wave of extrajudicial killings that was going on at that time was a woman who became the chair of the Human Rights Commission. She then became the Minister of Justice in the previous government, and she was then elected senator. As senator, she opened an inquiry into extrajudicial killings in the Philippines. She's now sitting in a prison in Manila. Her name is Senator Leila de Lima, and it is absolutely essential for all of us in the international community to start standing up for individuals who are at the coalface of protecting the international order and the standards that we value. Thank you.
Well, thank you very much, Philip, for this important addition to our panel. Without you, it would have been incomplete. And we have to remind, I think, throughout the year before we prepare for the next conference, what you said about the risks that we are facing. I just received a warning from the director of our society that we are running long and that we need to finish the discussion by 5 minutes past 12. And if necessary, we can have a few minutes more. I will, of course, keep that to heart, take that to heart. I'm sorry for the delay. We started already a bit late. I will now turn to the audience for your questions and invite you to be as precise and short as possible in formulating your questions. Whom may I give the floor for questions? Okay, over there, please, you have the floor. We have heard you on the previous occasion as well, so please be concise about what you want to say.
Thank you. My name is Jeannie Nguyen with Voice of Vietnamese Americans. I thank all the judges, all the panelists for all you have done to illuminate the law and keep up the orders in our international community for the last 7 decades. I believe we have progressed tremendously. I would like to come to your point that trust is now in crisis, and it's the international law that help to restore the trust. And it's the fact findings and the actions that we take across the board, with many governing leaders, governors, leaders of the world. I would like to ask, how could you sustain your judgment, the law, based on the law, without law enforcement? Case in point, from 1930s, 1945, 1975 till now, the treaties that many international leaders signed, especially the Paris Peace Agreements in 1973, and recently, the International Law of the Sea Treaty. How can we uphold the treaties to restore the law and the order of the world. Thank you.
Thank you very much. I will collect a few questions. Please.
Mark Wojcik from the John Marshall Law School in Chicago. Very quick question. If the UN Security Council refers a case to the ICC, it has done that with the statement that we're not going to pay for any of the expenses, and we expect that the ICC parties will carry these expenses. Is there an obligation on the Security Council to help enforce arrest warrants if they refer a case and the prosecutor decides to issue an arrest warrant?
Okay, thank you. Who is next? Mark, I'm afraid that your warning was very effective. Any other questions? Yes, please.
Hi, Katie Lundy, Millersville University. For those of us who are in the generation coming to power, in the millennial generation and so forth, for those of us who are high schoolers in college, be it our undergrad, our master's, or our law degree, for the board, and specifically for Professor Olston, how would you recommend that we help to help those who are in situations such as in the Manila case? How can we help with that justice? How can we help with the promotion of international law? And how can we inspire our peers to help those who are in danger and who are in need of aid?
Thank you. And then, if I'm not mistaken, the final question.
Hi, my name is Chuck Newcomb from the U.S. Department of Justice. You spoke about the crisis of confidence for a lot of the international institutions and tribunals. What are some of the success stories? What are some of the examples that we can hold up to speak with our colleagues to talk about the good that you are doing, or the examples that we can hold up for other or future institutions to follow from?
Thank you very much. I will now turn to the panel for a brief response to the questions, and I will go in reverse order. There were 4 questions. We have 4 panelists, so I suggest each of the panelists to choose just one question to respond to. I start with Philip Olsen.
I could destroy the whole panel by choosing the wrong question. So the question that was put directly to me is, how can the younger generation help? I think it's an extremely important question. I guess the most important thing is what the chair of our panel started talking about, and that is values. The values of internationalism, the values of human rights and global justice and so on. Those values are incredibly important. They're a threat very much in the local area, wherever we live, and there are many opportunities for all of us, whether students or otherwise, to stand up, I think, for those values. And the second issue is that if I was speaking to an audience 50 years ago, of course, I would have said, well, you can write letters or you can do op-eds or whatever, but you are part of a totally different generation. The role of social media it should not be seen as being dominated by one person who resides not too far from here and tweets at 5 in the morning. Social media can be mobilized by your generation for a whole range of different causes. And I think taking up some of the specific cases would be a very useful way to go. And you can generate an awful lot of pressure and move public opinion through those means. You're more powerful in that sense than your counterparts were 50 or 30 years ago.
Thank you. Now I turn to, who was it? Maurice Kamp. Yes.
Very briefly, I don't know if I'm going to answer any of the questions, but I think I would like to make myself very clear. I'm not challenging the fact that we might be witnessing some, let's say, unquote, crisis of international law, but it's not something new. It's periodic. Periodically, you will have such a crisis. What is happening in the China Sea or South China Sea or elsewhere is just, in some cases, breach of international law. in other cases, perception of the implementation of international law? Are we going to confuse the rule of international itself and the perception, the way the state perceive the implementation of international law? It's something which is completely different. I was the advisor to the Cameroon delegation to the Rome Conference in 1998. We were all very enthusiastic on the 17th July 1988 midnight when the statute was adopted, because the belief at that time was that that statute will be implemented, applied, irrespective of who has committed a breach of law or the statute of the person, and so on and so forth. Now, some years after, a part of the world, let's say African state, realized that it is basically something which is, for one reason or another, focused on Africa. And this is a perception and not the crisis of the rules itself. They still believe in the fight against impunity, but how do we achieve that? And that's the question. And we should take care of that. And above all, there is also the issue of power. If the Security Council can refer 2 cases from Africa to Security Council, why not cases from elsewhere? And these are some questions. We cannot just elude that and say, okay, everything is fine, or there is crisis because African states are not really, they do not understand what is going on. They understand it perfectly well. I just wanted to clarify this point.
Thank you very much. Judge Bruno Simon.
Success stories. Maybe 2 little stories from my own practice. My very first case before the International Court of Justice was that of Counsel for Cameroon in its case against Nigeria. A very, very complicated case, which ended up with a victory for Cameroon, essentially, namely that the Bakassi Peninsula, which was very essential for the maritime delimitation out into the ocean with a lot of gas and oil involved, that Bakassi Peninsula belonged to Cameroon. Nigeria first assented to the judgment, but then I think the province bordering Cameroon more or less indicated that they were less happy. And with Nigeria being a country with a certain centrifugal tendency constitutionally, then said that unfortunately they could not live up to the judgment. And then something set in, which in other context I have called ICJ plus, which means the fact that the ICJ is built into the UN system leads to possibilities of other UN organs kicking in and supporting things. And that happened through the UN Secretary General, who was instrumental in a commission to be set up. The commission started its work at the other end of the boundary at the Lake Chad and worked its way towards the critical spot. And when it reached the critical spot, all kinds of pressures on the participants had rendered their service. Nigeria agreed to withdrawing from Bakassi, and I think the compromise or the quid pro quo by Cameroon was that they accepted to protect the minority, an alleged minority on Bakassi. So that was, I think, an absolute success story. If I have time for another success story, I was more recently involved in an arbitration between Pakistan and India on the basis of the Indus Water Treaty. At the outset, when it became known that arbitration would take place, a professor from Harvard, a water expert, said, this is the worst thing that can happen in the situation of water resources. This is some kind of a, let's say, prisoner's dilemma thing. It can only damage. The award came out, and the same professor then wrote and said, this is an absolutely perfect solution. Both parties are happy with it. Well, they don't seem to be happy with it at the moment, but that's something I cannot disclose. But I think it's still a success story. So you come across success stories.
Thank you very much. And finally, I give the floor to Judge van de Wijngaard.
The chairperson has urged me not to speak too long, so I will resist the temptation to answer the question by talking about the cases that I think are emblematic of the success of international institutions, but we can do it during the break if you want. I will answer the punctual question about the Security Council. No, the Security Council has not followed up, in the sense the ICC, when there's a non-cooperation finding, it refers a case to the ICC, to the Security Council or the ASP, but so far we have not had any reaction in one direction or another. So there's a total silence on that front.
Well, thank you very much, Christine, for this short reply to one of the 4 questions. And now I feel that it is really time to conclude the panel. I receive, perhaps you saw me a little bit confused looking to the first row, where I received different signs. One sign that there is enough time, and the other sign is that we are running out of time. I will not try to find out who is right. Anyway, I will try to really conclude this panel before the original time schedule of 12:15. And then I have 65 seconds to say something about this panel, which really contributed new insights to what we anticipated that would be said about the subject of trust in international law and institutions. And I'm really grateful to the 4 panelists for these contributions. The walls, optimistic, although there are problems, a new balance between regional and universal perspectives on international law. And the concerns that we should also have about the present conditions in politics, about the future of international law. Personally, I want to add to this remark that it is true that we should not deal with the subject of trust as we used to do, and with peace and justice on the coat of arms of the city of The Hague in a naive manner. It's not out of a naive view on international law that we focus our research on trust in international law relations. It's not because it is superfluous to fight for peace and justice that the city of The Hague has put it in its coat of arms. And it is also important to continue to include new perspectives. For instance, that of the consequences of new technologies in information, communication, and technologies and warfare as well, new technologies in warfare as well, for the future of international law and the trust in international law. Thank you very much, dear colleagues, for these important contributions to our closing plenary. And now it's time to explain to you why we have to spare this last quarter in the original program. As you have heard, the deputy mayor of the city of The Hague is here. The Hague's commitment to the values that we discussed in these closing plenary extends to new developments that might change the processes and mechanisms which create or impair trust, especially the pervasiveness of the collection and exploitation of information. But The Hague also wants to relate to the past, to the history of international law, and the developments and the courage and the efforts that have brought us here together, dealing with these questions of trust in international law. And it's therefore that the deputy mayor of our city, Ms. Saskia Bruines, will take the floor and highlight how we feel connected with both the history and the future of peace and justice. We will stay here until the end.
Thank you very much, Mr. Hirschberlin, for giving me the floor. And thank you also for your help in preparation this discussion and moderating the meeting. Thank you very much. Ladies and gentlemen, bringing stakeholders in a variety of expertise together, that is what I like to do as a deputy mayor of The Hague. The Hague is a global meeting place. That is our city's strength. And as the legal capital of the world, representatives of The Hague's courts and tribunals meet frequently to discuss topics like the ones you are discussing now here in Washington. But if we really want to restore faith in international law and international courts, then we need to get other stakeholders involved as well. The physical world and the cyber world are rapidly becoming intertwined. Or let's be realistic, they already are. We urgently need a transnational judicial code for the cyber world. 2 days ago, the municipality of The Hague organized the Justice Stephen Breyer lecture together with the Brookings Institute and the Embassy of the Netherlands. And we discussed the general principle of accountability on the internet in order to secure protection of human integrity. Confusion over the boundaries between good and bad users of the World Wide Web is growing. And many experts recognize the need for greater international cooperation to facilitate investigation and prosecution of a wide range of violations. From cyber theft to terrorist attacks and war crimes, the necessary standards and protocols for applying technology to facilitate effective accountability are lacking. And to help restore trust in international law, the French lawyer Dan Chevet came up at the Brookings lecture with the idea of establishing the office of an international cyber ombudsman in The Hague. To put steps forward, we need to act. Like in history, peace activist Bertha von Suttner did. She encouraged Andrew Carnegie to fund the Peace Palace in The Hague. And let's mention Nobel Prize winner Tobias Asser, whose name is used for the Hague-based institute that Mr. Hirschballin leads. However, history is literally in our midst today. Mr. Benjamin Ferencz is a very important role model. Mr. Ferencz, thank you very much for being here today. The municipality of The Hague wants to pay tribute to Mr. Ferencz, and it's a great honor for me. At 98 years old, or young, Mr. Ferencz is the last surviving prosecutor of the Nuremberg trials. He has fought for the victims of war crimes all his life. In 2009, he received the prestigious Erasmus Prize in the Netherlands. The committee stated that he was the leading force behind the establishment of the International Criminal Court. Mr. Ferencz, your slogan of life is law, not war. You've seen horrible scenes when you as an American soldier entered the concentration camps like Buchenwald and Dachau. And yesterday, at the reception of the Holocaust Museum here in this building, I could feel in your words the motivation that led to your lifelong dedication. Mr. Ferencz, thank you for being such a strong defender of humanitarian law your whole life. You will remain a role model for every human being, especially also our youngsters all over the world, for many, many years to come. The Peace Palace is a symbol of hope throughout the world, as you are. And it is important that we keep this hope alive. And I'm proud to be able to help the world remember with a humble sign of honor to you, Mr. Ferencz. And so we solemnly promise you that we will continue to tell future generations about your beliefs and about your accomplishments for a better world. Mr. Ferencz, the city of The Hague has decided that your name will be given to a beautiful green walkway alongside of the Peace Palace. Would you like to come to this podium?
That's-
This is a person who works for the city government, but this is the beautiful street. We will hang it up in a few weeks.
Well, I
Shall I
appreciate
take this from you?
Yes, of
Okay.
course.
You want to
Well,
say something?
Do I want to say something? How much time should I say it in? I think I'll. All right, you handed me the mic. Now you're responsible. Let me say, first of all, I want to stress appreciation for that very big sign, Benjamin Ferencz pot. I have a terrible sense of direction, and this will help me when I get to The Hague to find my way. Let me also, since the Dutch government has been so prominent in honoring me in this very interesting way, let me tell you a little story about some experiences in Holland. It's been mentioned that the American Service Members Act has not yet been repealed. And therefore, there may be still a hazard that despite calling it the Ferencz Way, the United States may decide to invade Holland and rescue anybody being tried by the court. Well, didn't come as a surprise to me. When I was in The Hague one day, I was informed that the Service Members Protection Act had been passed. The Dutch declared it to be the Hague Invasion Act, which it was, by suggesting that if we arrested a criminal, the Americans would send the troops in to liberate them. And so a human rights group was organizing a protest. And the protest was to bring the flags of all of the nations that had approved the statute for the International Criminal Court, line them up on the beach facing the invasion path, which might be taken, sandbags lining, and they were all going to make speeches in protest against this anticipated invasion. And they asked me if I would join. And I said, no, I will not join in any protest against the United States, because I landed on the beaches of Normandy wearing the uniform of the United States. But I will make a statement in defense of the United States on the condition that I am allowed to haul up the American flag at the end of these ceremonies. And they said, fine. I sent them $1,000 for the flag. And when the time came, it was a rainy day. The place was in front of the hotel, the beautiful hotel on the beach. And all these flags got up and they said, oh, America, Service Members Protection Act, to hell with them. Senator Jesse Helms, who was then controlling the Senate of the United States, he can join them. And they were saying all kinds of such nice things about the United States. And when my turn came, the American ambassador was there for war crimes, and I asked him whether he would like to join me when I haul up the American flag, and he said he'd think about it, but didn't do anything. And I asked the head of the Coalition for an International Criminal Court, an American, whether he would like to join me. And he said, no, I can't do that. I said, all right, I'll stand alone. So I stood alone, and when my time came, I pointed out that I was there not to attack the United States, but to defend the United States, because the point of view which was conveyed in the Service Members Protection Act was a political compromise worked out and not truly reflective of what the American people think. The American people are divided, as we've seen, but half the people at least think that the Service Members Protection Act is a ridiculous piece of legislation. So when my time came, I hauled up the flag and I said, I want you all to join with me in saluting the flag for what it stands for. And I will recite to you the concluding and important lines: with liberty and justice for all. That's what America stands for. and I got a big round of applause. And I think that's appropriate to today's discussion, because how do you go about changing the world's order today, which is quite ridiculous? The system which we now live under, and I talk as a combat soldier who has been awarded 5 battle stars for not being killed in World War II. That's, I'm also grateful, of course, to the Dutch for the Erasmus Prize, which was money. But as some of you may know, I don't keep it. And how do we go about changing, bringing about and building the institutions that we need for a more peaceful and humane world? First, we have to recognize the current system, whereby if the heads of state are unable to agree, they send young people like you out to kill other young people like you, boys and girls, whom they don't even know, who never did them any harm, may never have harmed anybody. And then when they get tired of killing each other, they stop, each one declares victory, they rest for a while, then they start again. That is, in fact, the prevailing system today. Never mind all these excuses and so on. That is the essence of the world in which we live. That is a very dangerous world. I survived World War II, but nobody's going to survive World War III. We now have the capacity from cyberspace to cut off the electrical grid on planet Earth. If we do that, how long will it take for all of you in this room to be dead? The lights go out, the water doesn't flow, everything is disrupted, the radios don't work, the telephones don't work. How long would it take? A week? 2 weeks? I heard from Nuremberg, where I arranged to have some people hanged by the neck until dead, that it takes 8 to 10 minutes before you're pronounced dead. They only killed 1 million people. So what are you going to do about it? You're going to have long dissertation about this and about that. How do you change it? First thing we have to change, which we have not done enough of, is the political will. Basically, we're stuck in the fact that power lies in the hands of people who are more concerned with retaining their power than with creating a humane and peaceful world. When I was the prosecutor, I had before me 22 defendants selected by me on the basis of their high rank and of their education. I had, I think, 6 or 8 generals. Many of my defendants had doctor degrees. The lead defendant, Dr. General Otto Ohlendorf, was the father of 5 children. And he conceded that his unit, under his direct command, had executed about 90,000 Jews, as well as others, gypsies as well. But he wasn't quite sure of the figure because the men bragged about the body count. They were proud of how many more they killed. Ohlendorf, like the rest of the defendants, no remorse whatsoever. It was my saddest conclusion in Germany after several years that no one had ever said, "I'm sorry." And that weighed heavily on me. I stayed on in Germany to create the restitution compensation laws. There were various phases of a peaceful world. First, you stop the killing, stop the war. Next thing is you try to hold accountable as a deterrent those who were responsible for the killings. The third thing, which is usually forgotten, and new historical, was you provide compensation to the victims. It was ordinary tort law at Harvard Law School and other law schools that if you do an illegal act and an injury to someone, you have an obligation to try to make good. How do you do that when you have millions of people who are victims? Well, you do it slowly and carefully as best you can, but at least you try. And so I come to The Hague. It was at the invitation of the devout Catholic Chancellor, Konrad Adenauer, of the Federal Republic of Germany, who said horrible crimes have been committed in the name of the German people, and that imposes upon us the obligation to try to make amends. With that introduction, a small group was set up. I was counsel to the group. They represented all the leading Jewish organizations to negotiate a treaty between the state of Israel, which had been newly created, which didn't exist at the time the crimes occurred, the Claims Conference, which was a consortium of all the leading organizations, and which didn't exist either as a conference, and the German government, which was a new government and didn't exist at the time the crimes were committed and was totally destitute. They were smashed. The dollar was king and cigarettes was the only currency. So how do you negotiate a treaty with them? Well, we had to have a secret meeting place because there were people who wanted to kill us. Many people wanted to kill us. And it wasn't only from the German side, from the Jewish side, the state of Israel. Many people said, what, you're going to sit down with those murderers and talk about money for my wife, my mother, my father? Have you no shame? You all deserve to be killed. And so we call them terrorist gangs who set out to do just that. We were guarded by the Dutch secret police, German secret police, a few other secret police which were made secret. And one of the leaders of the terrorist gang was a fellow by the name of Menachem Begin. He became the prime minister of Israel and was awarded the Nobel Peace Prize. What's the moral of the story? Be careful who you call a terrorist. It may depend on your point of view. So if you're talking now, to come back to your theme, you cannot change the way people act if they believe that their interest is primary and that's the only important thing. And this goes back to Thucydides, saying that one with the power should use it, and that protects him. And we had the same thing with the German Kaiser Wilhelm and a whole group of Feldmarshal von Moltke and so on. And that point of view still prevails. It prevails in the United States, prevails in other countries. Don't rely on law. Law is meaningless. Many people in the United States express that. John Bolton said that in those words. There's no such thing as international law. So you have to realize that you have to have a change of heart and mind before you'll be ready to accept the controls which are vital to having a more humane world. How do you change the hearts and minds? You begin in the cradle and all and every step along the way. Who's going to do it? The young people. Can they do it? Of course they can do it. We pointed out the genocidal current system, and it is genocidal. There is no war without genocide because you're killing the group. There is no war without rape for the women who are here. We didn't charge rape at Nuremberg because the Russians would have objected. It was part of the policy. And it is part of the policy of most nations. Rape the women if you win. That's not the world you want to take. So you have to recognize that it's not weakness to be ready to compromise. It's not indecent to accept the other fellow's point of view, even if you're not fully convinced of it. And you have to have the courage not to be discouraged, because it's a very costly thing. But if I look at the chart as I see it of progress in the movement toward human rights, in my case, in the Einsatzgruppen case, I asked the court to affirm by international criminal law the right of all people to live in peace and dignity regardless of their race or creed, because they were murdered because they didn't share the race or creed of their executioners. I thought it was terrible then. I think it's terrible now. And I've been working all of my life to try to change it. And I'm not discouraged. The progress has been phenomenal. You've been listening here to this excellent presentation of the movement from nationalism to globalism, moving all through the various steps and the problems all along the way. For thousands of years, we have glorified war making. You cannot change that overnight or in 1 or 2 generations. We have made great steps. Everybody is teaching human rights today. It didn't exist before. The rights of women, which have come up, the elimination of slavery, none of these things are perfect. They are full of errors, but we are moving on. And the only way to continue doing that is to recognize that each of us has an obligation to do as much as he can. I sum it up, law, not war, and I get the cheers from the group if I say, never give up is one rule. Number 2 is never give up. Number 3 is never give up. There you have it. Thank you very much.
Thank you, Ben. Thank you so much for that inspiration. It is a fitting conclusion to our program. And thanks again to Dr. Ballin, all the panelists, The Hague, the Embassy of the Netherlands. This panel also was a fitting conclusion to a conference that's been focused on values and really points us forward to issues that we will need to continue to deal with, to examine. So now I'd like to invite you to join us for the closing reception, which will be in the Columbia B&C Ballrooms, jointly sponsored by the Embassy of the Netherlands and the City of The Hague. I'd also invite those of you who are able to stay after that reception to attend the championship round of the 2017 Jessup International Law Moot Court competition, which will begin at 2 p.m. in this very room. Finally, I'd like to thank once again our Executive Director, Mark Agrast, and all the staff of the Society for their work in putting together this wonderful meeting. Thank you.